Okay, get this down as always. Try not to be gully. All right. Last. Okay. All right. As always, I want to thank you for joining me for another edition of Disability Talk Live with Attorney Anthony Reeves. Some of you may or may not be aware, this will probably be my last broadcast for the foreseeable future. I have had the opportunity, I've been given a great opportunity to transcend on to something greater. So as such, I will be, or at least as of right now, I don't anticipate I'll be able to do any broadcasts in the very near foreseeable future. So with that being said, let's go ahead and get rocking and rolling to any of your potential questions or particular questions that you'd like to have addressed at this particular point in time. Now, a few things that some of you may be noticing that if it hasn't happened to you already, I want to give you a friendly heads up. You should, if your case is at the hearing level, you're probably going to start getting what we call these 5-day notices, and you're going to be like, what the heck is going on? One of the nice things about the way the Social Security Administration, like most governmental entities will do, is whenever there's changes in how the things are done, particularly the rules and regulations, you'll start getting extra notices from the Social Security Administration or whatever that government agency is. So it's important that you take the opportunity to review those documents. But just kind of as a quick response, this is basically what it is. It's telling you, just letting you know, that as a result of some recent changes, that now you have a responsibility to provide copies of your information or let Social Security know about any outstanding records. Let me see. I know this is odd. Don't go anywhere. Let me see if I can get my hands on one of these and I can break it down for you accordingly. Awesome. I know this is odd. I know you're probably thinking, Attorney Reeves, why are you walking off the screen, man? Talk to me. All right. I just want to give you a good example. You should be getting, if your case is at the hearing level, you'll be getting some information about all hearing requests that are pending on May 1st, 2017, going forward. And what's going to happen is that in this letter, it's talking about some recent changes with regards to some rules that are going to go into effect. So here's something that you need to be aware of. Social Security, in an effort to try to make sure your file is complete, they want to make sure that they have everything they need to know in order to decide your case. And so in an effort to do so, they're giving you and they're reminding you about your ongoing responsibility to make sure you tell them what's out there. Let me tell you why this is important to you. A lot of times what happens, and this is a little bit probably more so when you're representing yourself, you're so busy focused on your condition, your physical and your mental condition and so forth, that sometimes you may not realize that, especially at the hearing level, you still have an ongoing responsibility to continue providing them copies of your medical records, and you have an ongoing responsibility to let them know what's out there that needs to be obtained. So unless you tell them, they will not know. So I'm just going to go ahead and read exactly what it's going to say. It should say, if your hearing is scheduled May 1st, 2017 or later, we'll send you a notice telling you the date and time of your hearing at least 75 days in advance. Pretty straightforward. Now, the notice will tell you the issues the ALJ will decide, and if you object to the issues described, you must let us know in writing at least 5 days before. Okay. But here's the thing that you need to know about submitting evidence and written statements. Follow along with me here, okay? Social Security needs to make sure that your file has everything needed to decide your case. So you should send all information, evidence, statements, and requests relating to or about whether you are disabled to the LJ as soon as possible. So that's a nice way of letting you know that Social Security needs to know what's out there, what you're requesting, and what you're providing. So this way, when you walk into your hearing, they can issue it. Even though they probably are not going to tell you right there and then, but at least we'll have copies of everything possible relating to your case in order to make a determination of whether or not you're disabled. Now, here's a couple of things that you need to know. You have to send them or let them know about all evidence at least 5 days, business days, not calendar days, business days before your hearing. So for those of you who are like, what's the difference? Calendar days include Saturday and Sunday. Business days does not include Saturday and Sundays. So they're telling you in advance, we need to know at least 5 days before what's out there. And not only what's out there, you must send them or let us know about the evidence. So you have to do both. You either have to give them the evidence before 5 days, or you have to tell them about the evidence that you're submitting or the evidence that you're trying to obtain at least 5 days before. Now, one of the nice things about due process is that if by some reason, because sometimes weird things happen, and Social Security is not oblivious to that. So when things happen where there are some circumstances that may prevent you from being able to do that, Social Security will take that in consideration. But here are the circumstances, and they tell you this. Either one, if you miss this deadline and a decision has not yet been issued, the ALJ will accept the evidence if their actions misled you, if you have a physical, mental, educational, or linguistic limitation that prevents you from informing us or submitting the evidence earlier. So for those of you who are like, what's that? Well, they leave it sufficiently broad because the reality is they don't want to pigeonhole every specific situation because there's always going to be somebody that may be different. Imagine a situation where maybe you were getting the records together, the doctor changes your medication, and now the medication you're taking causes you to have some cognitive problems. Maybe you were in a car accident, you had to go into the hospital for a period of time. Maybe you were involuntarily admitted due to a mental health crisis. So all these things happens during that time period. The next thing you know, you find yourself in a situation where the deadline has passed because as a result, it prevents you from being able to provide them the information they need. Also, some other unusual, unexpected, or unavoidable circumstance beyond your control prevented you from informing us or submitting the evidence. That's one of those situations where it's kind of a catch-all. Like something weird happens. Like let's say, for instance, you were stranded somewhere, or let's say, for instance, you were kicked out of your place and you lost your letter and you weren't able to remember. Oh my God, I got to send this. But let me be blunt. I don't want anybody to walk in thinking in their mind, okay, Attorney Reeves is just giving us the example specifically what we can tell you that's going to hook us up. No, player, it doesn't work like that. Social Security. Hello, Markel. Hello, Love Green. Pleasure. Social Security wants to be able to, the judge wants to be able to evaluate the circumstances on a case-by-case basis to determine whether you had the phrase that we use in the legal community is called a good cause. Do you have a good cause? Do you have a good reason for why you did not provide the evidence to them in a timely manner? Now, here's the thing that you really need to remember. If the ALJ finds that you meet one of these conditions for not sending them or telling them about the evidence, the ALJ will consider the evidence. The ALJ will not consider the evidence if they don't find that you meet one of these conditions. Let me stress to you this. The judge is the final decision maker about whether or not he or she believes that you have given a good reason for why you did not provide them the information or tell them about the existence of the information in that 5-day window, before that 5-day window kicked in. So I don't want you automatically thinking in your mind, I've got a slam dunk situation and so forth. Remember, and I've said this in countless videos, for those of you who've been following me for years, you know I say this all the time. I'm like a broken record. You bear the burden of proving you're disabled. You're coming to the government and you're taking it upon yourself to provide them with information to demonstrate that your circumstances clearly puts you in a position where you should be entitled to disability benefits. So they now want to let you know, and ahead of time, how important it is for you to get that information to them as soon as possible, whether it be the information itself or the existence of that information. And the sooner you get it to them, the better. But they also recognize that there are circumstances that may arise that may impact your ability to do so. But again, it's not enough for you just to kind of roll the dice and say, I didn't feel like this, something weird just happened. I was, watching TV, Super Bowl was on that time. You bear the responsibility of demonstrating that your circumstances were unique that prevented you from being able to get them the information that they needed. So this way, they can make a determination regarding your case. Now, let me see if I'll do this. Okay. Kim said gave good information about how her husband's case is second level. He filed in 2015, date last insured is 2014. Some of you may see this happen. So this comes up every now and then, where Social Security says that your date last insured is this particular date. And some people look at that and say, are you saying that I cannot apply now? If the date hasn't passed yet, you're usually fine. Where DLIs pop in is when it's like 2014, like in Kim's husband's case, where what you're trying to do is you're trying to show the Social Security Administration that your disability began and continues to the point of now, before that date last insured occurred. So like in her case, 2014, her husband's case, he has to show that his disability began before 2014 and that it continues to the present. Can't be a gap, it's got to be a continual period of time. And most times, some reps will tell you the further back it comes, the more tougher it becomes because there's a greater opportunity for gaps in medical treatment. So I can understand that. So Nicholas says he read now that the change is that the doctors are not enough, may not be enough to prove you disabled. They're changing. Now let me kind of pause on that because I had just got through looking at the Federal Register about that as well. It's a catch-22 because basically what it says is there's not an automatic presumption that I believe it's like the psychological evaluator, medical consultants will automatically be given more weight than your doctors or vice versa. It's kind of a nice way of saying that they're kind of going to be looking at every one of those equally. Okay. My question is, is it normal for heart failure patients to be on a beta blocker and calcium blocker as well as nitroglycerin? Melissa, I can't tell you if that's normal because I'm not a cardiologist. Okay, your cardiologist would definitely let you know that. Markel said, I've had a lot of changes the past 3 years since I've been approved and moving out of the country to employ a full-time caregiver, and I will miss a couple months of care with a CDR coming. Will that be a problem? It determines the uniqueness of your circumstances. And I will tell you, and I've told this to people in a variety of videos, that I said it's tough for almost any representative to give you any clear-cut indication of what your information how your circumstances will play itself out without looking at your file, without looking at everything and saying, because I always tell people, representatives deal with specifics. When people ask questions, they ask based on a generality, but in order for the representative to be able to give you any type of positive or negative feedback about your circumstances, they require specifics. And trust me when I tell you this, you can't give me specifics in a sentence. Because what happens is that for every representative, we're going to have multiple questions about the circumstances of the question that you're asking. So, I always used to tell people all the time, when people come and they ask me questions, they would say, I got a question. I would tell them, there's no such thing as a dumb question, but there's also no such thing as a simple question. And they would look at me and say, I don't understand. The reason why I say there's no such thing as a dumb question is obvious. Any question where you're trying to attain knowledge is not dumb. I don't care if it's worded in a way that maybe somebody else wouldn't say it. That does not make it dumb. Okay, so please educate yourself and ask questions, but also recognize there's no such thing when you're talking to a rep as a simple question, because almost invariably most of our responses are it depends, because every circumstance dictates a different outcome. So the problem a lot of times is that most people think about the law from the standpoint of black and white. Reps, we look at it in gray because most people don't fall into black and white. They think they do, but most times it's the gray that's the problem, where you're in there and you're like, oh, okay, that's the issue. And what happens is that whatever's going on in that gray area may push you to the black or it may push you to the white, but there's no way to know unless you know the gray. So when people ask me questions about circumstances and they're like, hey, what do you think the chances are of this? And I tell them, it depends. They're thinking I'm being nasty, or they're thinking I'm just trying to gas them along so I can make some money off them. And I keep telling them, no, it has nothing to do with that. I said, when you're asking me a general question that requires a specific answer, you're asking me a general question to your specific situation, which requires specific facts for me to give you that answer. If you ask me a general question about, if a person requests a hearing, do they have to go? I can give you an answer. But if you start saying, well, what are my chances if I don't go? Well, then guess what? That's a specific question you're asking. Okay. Now, also, let me see. Crystal asks, I've gone through the hearing process, waiting on a decision. It's going on 2 months. I haven't heard anything, but I received a letter of the new change. Does this mean I'll be denied? If that new letter is coming out, they're sending it out to you regardless of whether you've had a hearing or not. Because I've actually gotten a few of those too for clients I've already had hearings on already. Like I have ones for where I've had hearings on already. I've had a couple for people who are coming up on a hearing, like literally within 2 weeks. So I've gotten the gamut. So I would caution anyone to automatically assume that if they got the letter in relation to the time period of their hearings and everything, that has some bearing on their case. I would probably politely say that it probably doesn't. I can't definitively say it because every office is a little different, but I can politely say that they're sending everybody out as a blanket notice, as opposed to trying to gerrymander it to people's particular circumstances. It's just easier just to get it all out there and call it a day. Okay. Now, I will tell you this and so forth. When you get these letters like this from Social Security, make sure you pay close attention to the wording of it. And I cannot stress this enough. If you're not sure in the grander scheme of things, when you're getting a document like this and you have somebody and you're not represented by anybody and you're not sure, please speak to someone to educate you about what you're looking at, whether it be calling the hearing office and asking them or getting a representative, because I don't want you to do anything that's causing a detriment. Because keep in mind this, if the court makes a determination that you have not given them a sufficient reason to let them know why you didn't give them the information about outstanding evidence, they can choose to not consider that evidence. And I hate for you to be in that situation. Now, I have Vito said I have an IDD level intellectual and my IQ is 64 with PTSD and paranoid schizophrenia. Can I get SSI? I don't know. I mean, I can't tell you specifically based on that statement if that alone would get if you get there, because I don't know, because there's two components to it. There is the non-technical and then there's the technical. The non-technical is the medical portion. The technical has to do with your assets. So Security can tell you very quickly about the assets portion, excuse me. But the medical portion, it depends on the circumstances of medical records. And I cannot stress this enough. It really, really just depends on what's in your medical evidence. Crystal, you are more than welcome, more than welcome to support. And B, I appreciate you giving me this. And I don't know if you just came here later and you may have missed what I just said, where I was saying, I always tell people ask for a general request based on specifics when they just get statements, and I can't really tell you anything without looking at your medical evidence. Most reps will tell you that. Okay. Now, Markel says, for disabled veterans like myself who are 70% when I was approved, now 3 years later, 100%, should they apply on their own or have them call you? I tell anyone when they're talking to me about whether or not they should consider applying, getting a representative, that it really depends entirely on their comfort level. Okay? The reality is, at the end of the day, it depends entirely on your comfort level. Do you feel comfortable applying for disability benefits on your own? Going through the process on your own. If you believe, because I've had, and just throw you out there to you, Markel, I've had vets come to me, 70%, 50%, 100%, and they'll say, Attorney Reeves, do I need you? And I'm like, you don't need anything in the grander scheme of things. The key is not so much do you need it. The key is really, how do you feel comfortable proceeding through the process on your own? There are a lot of people out there who've applied on their own, who've gotten disability benefits on their own, who've gone through the process on their own, and I applaud them. But then there's equal probably number of individuals, I don't know the numbers definitively, who probably felt like they needed to have someone. It really is more of a personal, it really, in the grander scheme of things, is a personal preference type of circumstance and situation. At the end of the day, it really comes down to what is your personal preference. What do you want to do that's going to work for you? Okay. Now, Bird says I got approved on February 16th at the hearing. Let me see. Congratulations. How long is the wait before I get a check? Bird, I talked about this before, and I've told people where I said it really depends on the circ. I know people hate this thing. You know, that daggum stuff depends. I said it depends because it depends on the type of cases you have. That's the one. If it's SSI only, the local office takes it, and depending on the local office, usually 30 to 60 days. If it's a DIB case, that means it's a payment center, still 30 to 60 days. If you have a combined one, it may take 60 to 90 days. If there are offsets, meaning if they have to calculate a long period of time for those individual months for SSI, and you were working at sometimes, you were living with different people at sometimes, that could be problematic. If you are SSD, and let's say you got workers' comp, let's say you have a VA pension in there, Let's say you have all kinds of additional weird things in there. So the reality is, okay, the reality is, okay, is that if Social Security has to do work, a lot more work to adjust, let me say this again, if Social Security has to do a lot more work in terms of the adjustments, that may take a moment or two. Okay, so even if it says DI, it depends. Like you said, you got 2/16/17 on the hearing date. You didn't indicate if that's when you got a decision. If you're telling me you got approved at the hearing, but you didn't get the decision yet and you're waiting on the decision, then I'm going to tell you nothing happens until you get the decision. Then that's what starts the clock with regards to pay. Crystal says, how accurate is the Social Security system that is automated? It always says to me the decision has not been made. It'll be 2 months waiting on the judge's decision April 7th. Oh. From my understanding from dealing with some of my clients, they are pretty accurate. See, what's probably unnerving you a bit, Crystal, is you probably don't know what's happening on the back end. So you don't see that maybe the judge is reviewing your file. You don't see that the judge is maybe considering asking for additional medical evidence. You don't see that the judge has written the decision and has given this, has made the decision and has given your information to a decision writer to write it. You don't see all those things. So what happens is the longer you wait, it makes you feel like nothing's going on, or maybe there's a glitch. But there is things going on, okay? So to answer your question, to the best of my knowledge, the system is actually on point with regards to that. So I think you're probably in a safe bet with regards to that, okay? Now, Royal says, I've been diagnosed with epilepsy and depression. Both my neurological specialist and psychiatrist put in writing, I'm unable to work, lawyer waiting for a date. What's my chances? First of all, let me throw this out here, and do not take this the wrong way, Royal. Ask your attorney. That is not trying to be funky. It's that your attorney is the one that has the one thing I don't have, access to your records. So your attorney knows from looking at your file the strengths, the weaknesses, the good, the bad, the ugly, all those things in your file, so that your attorney can advise you as to what your chances are. Your representative, your attorney, probably knows the court system in the area that you're going for, so he or she is probably more familiar with the judges than I am. And in light of any problem areas that need to be addressed. So I always tell people that every jurisdiction is a little different, but most courts, most places will allow the opportunity to seek a secondary opinion, or second opinion about something. And so when people come to me and they say, hey, I got an attorney, but I'm thinking about this, and what do you think my chances? I always start and tell them, start with the person who knows your case the best. Because if you're going to someone like me who's not looking at your medical evidence, who doesn't know your file, who doesn't know what court you're in, who doesn't know what judge you're going before, if I don't know any of that, I can't give you any key indication of whether or not I think your chances are good or bad. And more importantly, I understand your specialists and your psychiatrist saying you're unable to work, but I'm fairly confident it's probably a little bit more detail in that. So there's always all these extra details. So I tell this to people to say, if you are thinking about getting a second opinion, most of your circuits probably allow that. I'm not familiar with the rules and regulations for every state in the United States, so please forgive me, I don't know. I always tell people that before you start going to a second opinion, go and ask that question to the person who knows your case the best, and go from there. All right. If you have income from investments that is taxable, does that count as work income? Then fees are taken out of Social Security. Does that also mean that's the increase in some point? Okay. I always tell people this. Social Security, okay, let me pause for a second. Most of your reps, their responsibility is the medical development portion. They work on the medicals. They work on helping, making sure your case gets to the point where you're paid. Once you get into pay status, once you get into that point, then the onus is really upon Social Security to let you know and give you answers to all those particular questions. Okay. I know a lot of times people they're literally about going to Social Security because they're worried that by going to Social Security it may put their circumstances in jeopardy. But I always tell you that's what they're there for, to make sure they help you with the money aspect. All right. How much does the judge go in favor of what the vocational person says you can do? All right, Crystal, let me see if I can hit this pretty quickly. Most people don't realize the vocational expert is an expert witness. They're not there to make a determination about what you can and you can't do. They are there as a tool in order for the court to develop the record in such a way so that they can ensure that they have that additional piece of evidence to assist them in making a determination of whether the limitations in your file supports the determination of whether you're disabled or not. So when people ask me, well, vocational work expert said I could work. Actually, the vocational expert did not say you could work. What the vocational expert did was ask for, I'm not trying to say it never happened because everybody's different. I've never gone into a courtroom before any judge where the judge asked the person, the vocational expert, do you think this person can work? Because that's not what they're there for. They're there to answer specific questions that are posed to them in hypothetical formats based on specific limitations that could or could not include the ones that they're designed to supposedly include the ones that the court makes a determination are listed from your impairments. And what happens is that the expert is usually asked a variety of hypotheticals that takes in a variety of different circumstances. And based on those different circumstances, okay, the judge will determine which circumstances are supported by the medical evidence in your file. So if the judge makes the determination that the medical evidence in your file goes in line with the testimony of the expert that indicates that there are jobs available, then the judge can find that you're not disabled. If the judge's determination that the limitations that you have in light of the testimony from the vocational expert demonstrates that you cannot do those jobs, then the judge will say that you're not disabled. But it's important, and I cannot stress this enough, do not go in there thinking that this person is the person who's going to decide that you're disabled. You're welcome, Crystal. This person is really there as an expert witness. They don't rule the day. They don't designate the day or whatever carry the day, whatever phrase you want to utilize. They are there as a tool, an expert witness that the judge utilizes. The judge is ultimately the final decision maker on behalf of the Social Security Administration. That's the person who's going to make that decision. Okay. Now, again, as always, when you find yourself in a situation, if you have any questions about finance, like when you get into the situation where you're getting disability benefits and you have a question about finances, do not walk in the dark and try to, and I know what people do. Research, I got you. I got you. You're going to research, okay? You're going to go online, you're going to go to different chat groups, and you're going to ask all kinds of questions. And I encourage you, educate yourself as much as possible. But let me be blunt when I tell you, the people that's responsible for paying you are the people that you really should be asking those questions to. Most people are afraid to ask the questions because they're worried that by asking them, they will be alerting them Social Security to something that may either cause their benefits to be reduced or suspended altogether. I get that. I get that. But I just need you to understand the grander scheme of things, that they are there to serve as to serve that purpose for you. Let them do their job. Okay? Now, last question, because I got to shut this down. Vito says, I have a clinical psychological evaluation that states I'm not feasible for work. Is that good for my case? I want to throw this out here as my final parting shot here. Whenever people talk to me, I have to remind them about something. Social Security has to take in consideration the weight of all of your evidence. That's important for you to understand. Most people, when you're going to a hearing, if you're blessed and have the opportunity to have different treating sources, it is important for you to understand this, okay? They don't just look at one document in a vacuum. So if you had a comprehensive evaluation, they're going to look at whether other evidence supports what that evaluation says, if that evaluation is helpful or harmful. So it's important because a lot of times people have the idea in their mind that they're thinking about evidence from a slam dunk standpoint. I got this slam dunk piece of information, so I'm in there. And I tell them, you cannot think about it like that because that's not how it works. They must look at everything in its totality with all of your evidence to make a determination of whether or not your condition is such a level where it's supported by the other evidence in the file. Okay? All right, everybody. As always, as I indicated before, this will be my last Disability Talk Live for the foreseeable future. I wish all of you the best. As always, I appreciate the questions that you have coming at me, Vito, Royal, Crystal, Virgo, 09. My man Jonathan is in his Pacific, and so I want to give appreciate the shout out for all of you giving me your questions and answers. So please, by all means, let me throw this out here for those who are watching this as well. Make sure you utilize the resources that are available to educate yourself. But if you don't know, do not hesitate to reach out to someone and ask, whether it be a representative, whether it be Social Security. Do not stay in the dark. Bring yourself to the light so that you can do everything possible to present the best case possible for you in terms of your application for disability benefits. It's a long process, and you want to do everything you can to present your best case forward. Good luck to y'all. Thank you very much, and take care.